to a discussion of the rule of law and judicial independence with former U.S. Attorney General Alberto Gonzales. I am Dira Imam, president of the Beverly Hills Bar Foundation, and I'm honored to be here today to introduce your moderator for this program that promises to be such an important and fascinating discussion. But first, I want to encourage you to learn about the foundation and the good work that we do. We host programs like today's to educate our profession about critically important issues, including protecting the rule of law, judicial independence, and access to justice. We host an annual writing competition for law school journal articles about the rule of law issues. But our largest project is that for more than 50 years, we have been providing scholarships to law students who are committed to practicing public interest law after graduation. We would be grateful for your support for this next generation of leaders, and staff will be dropping the donation link into the chat. And now, I am delighted to introduce our moderator, Vince Farhat. Vince is my colleague on the foundation board, and we also previously served together on the BHBA Board of Governors. He is a former assistant United States attorney who served in both the major fraud section and the civil division of the U.S. Attorney's Office for the Central District of California, including under Attorney General Gonzales. Until recently, Vince practiced law full-time as a partner at Jeffer Mangels, Butler, and Mitchell LLP, where he chaired the White Collar Defense and Investigations Group. As of this school year, he now splits his time between the firm and his position as a visiting associate clinical professor of law at Loyola Law School here in Los Angeles, where he teaches legal research and writing, white collar defense and investigations practice, and ethical lawyering. When Attorney General Gonzales so generously agreed to do this program with us, we knew immediately that Vince was the ideal interviewer. And now I'll turn the program over to him.
Thank you, Dira. Very kind, thank you. So good afternoon, everybody. I wanted to start by properly introducing our special guest. Alberto Gonzales is the Dean of Belmont University College of Law. And under his leadership and under his guidance, Belmont was fully accredited by the American Bar Association in 2016. This was after graduating its first class just 2 years before, so it was a record accomplishment. Dean Gonzales attended the United States Air Force Academy. He received a Bachelor of Arts from Rice University and his law degree from Harvard University. Dean Gonzales was nominated by President George W. Bush and confirmed by the United States Senate as the 80th Attorney General of the United States in February 2005. He served as Attorney General until September of 2007. Dean Gonzales has held a number of other very senior government positions, including he served as a justice on the Texas Supreme Court. He was Texas Secretary of State. He was general counsel to the governor of Texas, and he was counsel to the president of the United States. And before entering government service, Dean Gonzales worked as a partner at the Houston law firm Vinson & Elkins, a top firm. So Dean, thank you and welcome, and thank you for joining us today.
Thanks for having me, Vince. I'm looking forward to this. This will be an interesting discussion. You've presented some very interesting topics for us to ponder.
We'll try to keep it interesting. But I guess, first, I really want to talk about, you are a Republican. You've served in high-ranking positions in Republican administration. Yet, it's a matter of public record. You endorsed Kamala Harris in the 2024 election due to concerns about rule of law. First question is, why did you endorse Ms. Harris?
Because of concerns about the rule of law. Listen, I am a lifelong Republican, but when people ask me today, what are you? Are you still a Republican? What I tell them is I'm a Bushy. I support the policies that President Bush championed, that I had a role in protecting. I'm very proud of our service. It was imperfect. I'm the first to admit that we've made mistakes. If you believe you're not going to make mistakes at this level, you have no understanding or appreciation how difficult these decisions are. So we were imperfect, but we did our best, particularly in the war on terror, and taking some controversial steps in trying to protect America. So it's the reason I've learned a lot from my service, and I know I know how powerful the office of the presidency is, and why it's important to have someone with great integrity in that office. And I just felt that Kamala Harris would be a better choice. I knew that I would have some concerns and questions about her policy positions, and that's understandable. I had questions about some of Bush's final decisions. Some I didn't agree with, but of course we carried them out. But that's the reason why I decided to support Ms. Harris.
And what were the specific issues or the concerns that you had as you were evaluating the candidacy of the Republican nominee? What was it that specifically caused you to say, look, I want to go with rule of law as opposed to necessarily ideology? What did you see in that candidacy that gave you pause?
Well, if I could list just a few, how about this was a convicted felon? How about inaction during the riots of January 6th, when President Trump was still president and could have taken steps to protect the Capitol and those defending the Capitol, and members of the Senate and members of the House? How about multiple bankruptcies of his companies, the Trump companies, over his years as a businessman? How about the multi-million-dollar judgment for sexual abuse involving Jean Carroll? Um, so these are just some examples of why I had concerns about the character of this individual. I have to admit, I've only met Donald Trump once, so I can't say that I'm an expert or I know him that well. And I think it was there was I can't remember the name of the person who had this saying that reputation is what men and women think about you, but character is what only God and the angels know about you. So, I can't say for sure about this person's character, but you look at the track record and it certainly gives you some indication.
Some people who are supportive of the president would say, look, we had a presidential administration once before with Donald Trump. They will say the world didn't end. There was not a complete erosion of the rule of law, and have said that, that concerns were overblown, that maybe people should not have approached this and said that this will be a constitutional crisis or some sort of constitutional apocalypse if the man is reelected. We are now about a year in, almost a year in to this new administration. And as you look back in this last year, have your rule of law concerns been realized? If so, in what way?
I don't know that all of my concerns have been realized or the concerns of others have been realized, but I think it's fair to say that there has been an erosion of confidence in the rule of law because of systematic erosion, systematic attacks on institutions, Department of Justice, and we'll talk about that being one of those. So that is of great concern to me, and but I think most of us had some idea that this is the path that this administration, this president would take. What has been more surprising and much more disappointing is the inaction by our Congress. From my perspective, I think the framers envisioned that the Congress would be the most powerful branch in our government. And they've been missing in action. And I think that inaction has allowed this president to do things that it would have been unimaginable during the time that President Bush was in office. And from a whole host of things, like not exercising their oversight with respect to confirmations and allowing recess appointments or appointments we'll talk about, I suspect, which is at the Department of Justice, the use of force, and not respecting the role of Congress in terms of the use of force and the commitment of U.S. forces around the world. So it's been troubling, and there's no indication that it's going to slow down. Again, I'm not in the administration, so I don't know what their thinking is, what their current plan is. a lot of speculation about what may be coming down the road, some speculation about whether even President Trump is going to leave at the end of his second term, which, I think is kind of out there, but I hope that's not the case. So yes, there are some things that I think that we're seeing that I'm worried about. One final thing I'll just mention that we may get into, and that is, it appears the Department of Justice is being used to impose retribution against people that I think President Trump feels he was offended by. And one of the most disappointing things as head of the Department of Justice, I know how hard our prosecutors work at the Department of Justice, and I commend you, Vince, for your service. But the notion that those individuals, those investigators and prosecutors who were successful in prosecuting the January 6th rioters, that those prosecutors and investigators were fired for doing their job well, and then to make it even worse, pardons those individuals who were actually convicted of assaulting police officers and assaulting our Capitol. So that's been disappointing. And these are all things that really gave me a great deal of concern.
Understood. So let's pivot to the question of retribution or weaponization of DOJ. We've heard that phrase, weaponization of DOJ. I wanted to start the topic by base touching with you. During your time as Attorney General, were there policies or standards in place that the department tried to follow to avoid the perception of political prosecutions? What was done in that regard?
There was a set of policies that were in place after Watergate, limiting contacts between the White House and the Department of Justice with respect to prosecutions, investigations, and prosecutions. Obviously, there are communications that have to occur between the White House and the Department of Justice with respect to budget issues and policy development. But with respect to investigations and prosecutions, there's been this policy, this practice put in place about limiting contacts, communications only between the White House Counsel and the Deputy Attorney General or the Attorney General with respect to an ongoing investigation or prosecution. And that's been standard since Watergate. I can't tell you the number of times that I had conversations with President Bush, who was very interested in a certain case or matter. And I would tell him, as much as I felt comfortable telling him, but reminding him how important it was that he not get involved in an investigation or prosecution, because it would hurt him, it would hurt the presidency, to create this appearance that in fact he was putting his thumb on the scale, because everyone at the Department of Justice, of course, works for the President of the United States. And so that was a practice that we followed. And I tried to be very, very disciplined in ensuring that lanes were people in doing their work stood in their lanes. I'll give you an example, if I may. When I was the Attorney General, Chris Christie was the U.S. Attorney in New Jersey, and he prosecuted the son of someone in the Trump family, and that person went to prison. That person got sick, and the family asked for this person to be released so that person could go home as a sick person. And so Chris calls me and says, I don't think this person should be released, but I want to know what you think. And I told him, I said, Chris, this is your case. You prosecuted this case. You know the facts here. I don't. I'm not going to tell you what you should or shouldn't do here. Exercise your best judgment. This is why you were confirmed. The Senate has confidence in your judgment. You need to exercise your good judgment. And so I guess that was an example, maybe not a good one, of maintaining lanes and understanding that reinforces confidence of the American public that the administration is going to look at the facts and make the best judgment with respect to what we need to do to protect the rule of law.
Got it. There seem to be competing narratives of weaponization that we see in our legal and political, discourse. Supporters of the administration will argue that it was the Biden administration that first weaponized DOJ, by indicting the former president to keep him from returning to office. And supporters, of the president's administration contend that current leadership of DOJ is restoring what they consider to be an equitable balance to law enforcement policies. On the other hand, opponents of the administration argue that the Trump administration has utilized DOJ by investigating and indicting political opponents, and they argue that it's a dangerous new precedent. As you look back now in the fullness of time, how do you weigh the case on these competing narratives of DOJ weaponization?
Well, first of all, let me just say that a political actor can and should be investigated and prosecuted if, in fact, they have engaged in wrongdoing. But the key is whether or not that person has, in fact, engaged in wrongdoing. Um, excuse me. From my perspective, I worry that you begin with the public statements from the president about retribution, and that he is he is your retribution, he told his supporters. And then you see actions like going after James Comey, going after John Bolton, going after Letitia James. And it may be at the end of the day, the case can be made that they engaged in wrongdoing. But it's the rhetoric leading up to this, and then putting these individuals up through these ordeals that cause one to wonder whether or not this is nothing more than just retribution. And I think that's harmful to the rule of law. It's harmful to the Department of Justice. I think it's created great sadness in the department, employees of the Department of Justice, where morale has to be very, very low because, as you know, less than 1% of the people that work at the Department of Justice, and there are over 100,000 people that work there, less than 1% are political appointees. Over 99% are career people. They go to work day in and day out, irrespective of who the Attorney General is, irrespective of who the President is. And so the politics for them is secondary to their work on behalf of the American people.
Yeah. And I'm assuming that the concern also is the impact of public confidence in the justice system. If you could speak to that, these competing narratives of weaponization and what that does to public confidence.
Well, there's no question about it because these conflicting narratives do cause confusion. They sow confusion, I think, in the minds of the American public, and they worry whether or not is justice being weaponized, is justice being politicized. And I believe that's dangerous to have the American public not have confidence in our criminal justice system because that undermines the rule of law. And without the rule of law, Vince, we don't have a democracy. We don't have a United States. It is one of the things I think that makes America unique. And it's one of the things that has stood the test of time. And I think slowly but surely we're seeing some erosion in that.
Yeah, none of us have crystal balls, but if you think ahead to the next administration, do you think there'll be a return to norms where these lanes are observed and these norms are followed? Or do you think it's the new normal?
I hope, well, obviously it's going to depend upon the person we elect as president of the United States. If that person is a person of integrity and with an understanding of history and a respect for human dignity, I think that person is going to push the administration towards the old ways and not be a person that is pursuing retribution. I'm hopeful it's going to be someone. One of the things I really admired about Barack Obama, I didn't agree with some of his policies, but hope and change. He had a very optimistic, hopeful vision for America. Americans respond to a positive vision. They respond to someone who says, listen, I've been at the other side of the mountain. I know what is possible in this great country. You come with me and I will take you to a better place. Now, the journey is going to be difficult at times, but you stay with me and we're going to achieve greatness together. So I think that positive vision is very, very important. And I think someone who has that kind of positive vision, hopefully will be successful in the next election. And hopefully that person is going to be respectful of the separation of powers and things like federalism, separation of powers, rule of law, these are all things that are very important and what makes America, America. And I'm hopeful that we'll see that again.
Yeah. So you touched on, when you mentioned retribution, the cases of Comey, James, former National Security Advisor Bolton. We don't have time to really dive into the details of those cases. We have included materials in our compendium for CLE credit talking about these cases. But I want to touch on one issue that underlies the Comey and the James cases, and that goes to the appointment of United States attorneys. Unlike the case involving Mr. Bolton, the Comey and James cases didn't appear to go through what we would consider regular channels. So the president publicly called for their prosecution. He appointed an attorney who had been his personal attorney, Lindsay Halligan, to serve as the Eastern District of Virginia U.S. Attorney. Comey is challenging Halligan's appointment in one of his motions to dismiss. And separate and apart from that, we've seen a raft of motions to disqualify U.S. attorneys brought by defense counsels. Most recently, just last week, here in our district, in the Central District of California, Judge Michael Seabright, who is a Bush nominee, ruled that Bill Asaley was unlawfully serving as acting U.S. attorney here in the Central District. So I'd like to start by asking, during your time as Attorney General, were there policies, standards in place relating to the nomination of U.S. attorneys? And what were those policies? How did the administration manage that process?
People may not understand that with respect to appointments like U.S. attorneys, U.S. marshals, members of the Senate, members of Congress have a significant say, at least they did during the Bush administration. I think before that, and I suspect since afterwards. If there's a vacancy, say with respect to a U.S. attorney, what we would do as a Republican administration, we would contact the local Republicans and get names for people that might qualify to serve effectively as a U.S. attorney. One of the things we'd look at, of course, would be judgment, experience, but also age, because this would be an opportunity, quite frank, and I'm being very honest here, to credential someone who then might rise up to do something very significant in our government in Washington, or perhaps in the respective state. And so we would gather those names, and oftentimes, if we didn't have the support of the home state senators, we could not get a U.S. attorney even nominate a hearing, much less confirmed. And so home state senators had a great deal of say in terms of who the president would nominate and hopefully ultimately get confirmed as a U.S. attorney. And obviously what we looked at experience and we looked at judgment. Those were the two things that we really looked at. Obviously education was important. And that's what we looked at in making a nomination. And hopefully that person would do well in the confirmation hearing. And as a general rule, again, with home state senators' support, they would be confirmed.
So the disqualification motions, there have been some in Nevada, New Jersey, and California. Apparently, when we look at these cases, they involve situations where the Attorney General has selected someone to serve as what's called the first assistant U.S. attorney, so they can automatically fill a vacancy. And we read about first assistant, acting U.S. attorney, interim U.S. attorney.
Yes.
I think to those who haven't served in DOJ, it's a little confusing. Can you just give us a quick tutorial? What is the first assistant U.S. attorney, and what's the difference between an interim and an acting?
Well, I've served in DOJ as head of DOJ, and it's confusing to me at times. That's quite honestly. The first assistant is, as the name implies, the number two in command within a specific office. And if the U.S. attorney is unavailable or the position is vacant, as a general rule, that person makes decisions for that office. The difference is with respect to a vacancy, the AG can make an appointment. That is called an interim appointment, and it's for 120 days. And after the 120 days, that person is out. An acting U.S. attorney is someone who by statute, this is under the Federal Vacancy Reform Act, who by statute, it can be the first assistant. And so being the first assistant is important, because if you're the first assistant, you're automatically going to qualify to be the acting U.S. attorney, and that I think is for a period of 210 days. So those are the major differences. The AG appoints as an interim attorney, the AG makes that appointment. With respect to the acting attorney, U.S. attorney, that is something that's a presidential appointee, and the length of time of service is longer as an acting versus an interim. The confusion comes from the fact that sometimes an administration will try to combine the two with respect to one individual, and sometimes the times called for in those two statutes get conflated, and it can be somewhat confusing. I think what's very important for your viewers to understand, though, is that this is a way for an administration to avoid Senate scrutiny of someone serving as a U.S. attorney or in that position. And one of the things I'm very surprised about is that the Senate is not screaming about the fact that their prerogative to say grace over the qualifications of someone serving as a U.S. attorney, either on an interim basis or an acting basis, that person is qualified. And but we're not seeing that. The Senate is missing in action. And as a result, the president is able to, relying on these two statutes, put people in place. And that's some of the confusion you're seeing and why some of these appointments are being challenged in the courts.
And this, it goes back to your point that you made earlier about the inaction of the Senate, the failure to engage in advice and consent. When you were serving as Attorney General and serving in the Bush administration, was there ever a time where you sought to meet and confer, you didn't get consent, so somebody was appointed on an interim basis as a recess appointment? I mean, does this have precedent in recent history, or is this really unusual, what's going on in the current Trump administration?
Well, there's certainly precedent in having an interim U.S. attorney or having an acting U.S. attorney because vacancies occur. Sometimes people die, sometimes people get incapacitated. And so there is a need to have someone in that position. But I think seeing it at this level and to this degree, I think is unusual. And again, the most disappointing thing for me, from my perspective, or surprising thing, is the fact that the Senate is allowing this to happen, because they could do something to prevent this from going forward.
Well, and you mentioned, death and the Federal Vacancy Reform Act. It's interesting, in Judge Seawright's order, he disagreed with the government's reading of the FVRA. He ruled that the at issue provision really only applies if the previous U.S. attorney had passed away or resigned or was incapacitated. But it's notably, his order calls for Mr. Assaili to continue as the first assistant U.S. attorney, which effectively leaves him in the top slot. How does that work? How does one sign pleadings as in that role? How does that work?
Well, because that is a top spot in the office, and so he does have the authority to do that. So it's as simple as that. And I think you're right. I think it raises questions in the minds of a lot of people about, well, what difference does it make? I mean, he's still there, and that raises a good question. Yeah, what difference does it make? So doesn't this completely flout the authority of the Senate in the oversight of who's serving these positions?
And obviously, there are a lot of great people in the local office working hard every day to try to do justice every case, one case at a time. And I wonder the effect it might have on our career prosecutors and civil attorneys when they see this sort of turmoil.
Well, you're absolutely right. I think for the most part, the work is going to get done. These are well qualified, well determined individuals whose job is to prosecute wrongdoing. Nonetheless, it is somewhat disruptive to have all this going on, because leadership in an office like that can be very, very important. Now, it will continue, but nonetheless, it's distracting to have all this going on, this uncertainty about whether or not the person at the top, does this person really have the authority to act on behalf of that office?
And it raises, from the defense perspective, concerns and constitutional questions about the authority to supervise cases, and whether a defendant's been properly, been afforded due process, and whether those cases should be indicted. or
Well,
dismissed.
it certainly gives the defense something to argue. That's for sure.
Yeah. So you touched on DOJ independence, but before we go there, I wanted to, because you've had a unique background. You've served both as White House counsel under President Bush and later served as Attorney General. So you've got the perspective. And I think that there is not a lot of awareness, certainly wasn't on my part until I started preparing for this, about the different roles those offices have. And so if you could, with respect to the White House counsel, what is the role of White House counsel and who is the client?
I view the client as the office of the presidency, not just the president, but the entire office of the presidency. And um, my job was to ensure that decisions made by the president were supported by the Constitution. And this became particularly important in the war on terror. The number one question is, what authority did the president have to authorize certain actions that in many cases were controversial? Did the president have the authority? It began on 9/11. Did the president have the authority to shoot down a commercial airliner heading toward a government building, for example? And then after that, did the president have the authority to shut down certain industries, shut down the airline industry, for example? And then after that, it became, did the president have the authority to house prisoners at Guantanamo Bay? Did he have the authority to determine that the Geneva Conventions did not apply? Did he have the authority to authorize certain kinds of interrogations? Did he have the authority to authorize certain kinds of electronic surveillance? Now, it wasn't Al Gonzales providing the legal advice on those questions. What I did was to make sure that I involved the lawyers at the Department of Justice, CIA, Defense, State, NSA. And lawyers would come to my office and we would debate these questions. Did the president have the authority to do this? And as you might imagine, the discussions were heated. There was great disagreement sometimes among some of these issues. But at the end of the day, I would turn to the representative from the Department of Justice, and oftentimes it was the Deputy Attorney General. Sometimes it would be John Ashcroft, the Attorney General, but most of the time, the Deputy Attorney General or the office or the head of the Office of Legal Counsel or a representative of the Office of Legal Counsel. And I would tell them, okay, you've heard the competing arguments. You have the final word, because the Department of Justice is charged by statute to advise the executive branch, and also because at the end of the day, when these actions are going to be challenged in the courts, it would be the Department of Justice defending these actions. And so whenever I walked into the Oval Office to advise the president about the scope of his authority, I would sometimes let him know about the disagreements amongst the lawyers. But I would always tell him, this is what the Department of Justice believes and recommends. And Mr. President, we're going to follow their advice. Because I thought it was important for protection of the president that he had the backing and support of the Department of Justice. And that's the way it would work. Again, my job was to facilitate. Sometimes the president would ask me for my views and I would share them, but then I would quickly pivot and say, but the Department of Justice is the final word on this, Mr. President. And he followed their advice.
So that was when you were as White House counsel. Then you were appointed and confirmed to serve as the Attorney General later in the administration, but we were still dealing with war on terror issues. And now you are playing a different role.
Yes.
And still confronting these issues. Did the process, was it different? Did it change? Did your view of the White House counsels become different because you had this new role? Who was White House counsel, by the way, when you served as Attorney General?
Harriet Miers was a White House counsel who had, dealing with this cough. Harriet Miers had been the staff secretary in the White House. I knew her from our days in Texas, and we were good friends. So that relationship, by the way, I can't overstate how important relationships are. I tried as best I could to establish a good relationship with John Ashcroft, because having a level of trust and understanding and being able to communicate freely your views about a tough legal issue is incredibly important. And so that relationship that I had with Harriet Miers was very, very important. But to be quite honest with you, when you're the Attorney General, you spend less time dealing one-on-one on some of these issues because you have a team of thousands of lawyers, and they're the ones that go to many of these meetings, and they come back, and we have private discussions within the Department of Justice, and we reach I take recommendations and sign off on a particular recommendation, and then that gets communicated back to the White House. So it's a much different role. I'm often asked, of all the things I've ever done, which one did I enjoy the most? Being a cabinet secretary is incredibly, it's a proud thing for me. It's incredibly cool. You're driven around in 2 FBI Suburbans with agents carrying machine guns. You fly around the world in a G5 jet, but you have to go testify to Congress a lot. You have to deal with the media a lot. In every decision you make, there are winners and losers. So it's an incredibly difficult job. I think it's probably one of the more difficult cabinet positions there is. Being White House counsel, you get to go work in the White House. As an American citizen, it doesn't get any better than that to go to the White House every day. And I got to advise on the most serious issues you could possibly imagine. And that's why I went to law school, is to be able to be involved in these kinds of decisions, and to be able to do it during a historic period, to work and to do it for a man that I really knew, admired, and respected. It doesn't get any better than that. So not by far, but I really enjoyed my service in the White House.
We have a question from one of our participants, and to set up the question, it has to do with codes of ethics. First question is, at the Department of Justice during your tenure, what codes or what standards did AUSAs and department lawyers need to follow around conflicts of interest generally? And the next question that the viewer has posed is whether you view other branches like the Supreme Court, the judicial branch, should have similar codes of ethics. So go ahead and take the question.
Well, there is a manual, a DOJ manual, that lays out quite clearly about the expectations in terms of ethics of all the employees, but in particular investigators and prosecutors. So those are expected to be followed. There is an Office of Professional Responsibility. That office exists to ensure that lawyers meet their ethical obligations. And so if a lawyer strays from those ethical obligations, or that could be investigated by the Office of Professional Responsibility, and it's possible your license gets suspended. And so, yeah, it's something that's taken very, very seriously. It's not my place to opine as to whether or not the Supreme Court of the United States should have an ethics policy, although I will freely say that I think it's I don't know why the court wouldn't impose something, some kind of disclosure requirement. If you're willing to accept a gift, you should be willing to disclose the gift. Not an ethics requirement that you not accept certain kinds of gifts, but simply that you disclose certain gifts, maybe above a certain level. I think that would enhance the reputation of the court, which is suffering, I think, from loss of confidence in the minds of the American people these days. And that's not going to restore it all. I think the American people are going to look more to the decisions of the court, but I think having some kind of ethics policy is something that I might advise the court to consider.
You mentioned the Justice Manual. I remember it used to be called the U.S. Attorney's Manual, or the USAM.
That's right.
We've included provisions of the Justice Manual in our program materials, and the Justice Manual addresses the issue of prosecutorial independence. It talks about DOJ being impartial and insulated from political influence, and that investigatory and prosecutorial powers be exercised free of partisan consideration. Those are in our materials. There's also a 2021 memorandum, Attorney General memorandum, that's included in the materials, that apparently is still good law, if you will, or good standards, still on the website. It talks about DOJ not advising the White House concerning pending or contemplated criminal or civil enforcement actions. The president's nominee to lead the criminal division, Tyson Duva, testified on October 22nd at a Senate confirmation hearing that a new policy governing contacts between DOJ and the White House is forthcoming. So he acknowledged in a follow-up letter that that 2021 memo is still there, but changes are forthcoming. And I'm wondering, as you compare what you've described in the Bush administration versus what you're seeing in this current administration, how do you weigh the case on whether there's independence or not? I mean, you've said you think that they're being kind of used as a tool or whatnot, but how do you weigh the case on the differences between what you guys did and what's being done now in terms of respecting the spirit of the Justice Manual?
Well, I think the Department of Justice now operates under in a different environment. And one of the major reasons for that is the case of Trump versus the United States, which provided immunity to the president and sort of made it clear that the president of the United States, one way that I've heard some describe it, is the Supreme Court for the executive branch. What the president says goes. If he says something is lawful and can be done, then for the executive branch, it can be done. And so that is a big difference today. And the Department of Justice, someone at the Department of Justice may say, I don't think that's right. I think that's unlawful. But everyone works for the President of the United States. He's the chief executive officer. And so he can make that decision on his own. I wouldn't advise it. I would never advise a president, particularly one who's not a lawyer, to make legal conclusions, but he can. And that's what we got out of that decision, quite frankly. And it can't be, the decisions can't be questioned. One example, this is an extreme example, and I'm not suggesting this president would ever do that. But, it's possible, a core constitutional power of the president is the pardon power. And it's possible that an individual who has committed a crime wants to get a pardon and gives $1 million to the family of the president, and the person receives a pardon. The court says you cannot go behind the motives of the reason for the exercise of constitutional power. That to me is, I was going to say interesting. It's somewhat alarming. That is, and I guess the answer is, well, the response should be that if that were to occur, then the House can try the president and the Senate can remove him, impeach and remove the president. But we've seen how ineffective that process has been, and so I worry about where that leaves us.
So regarding presidential immunity, in 2018, during the Mueller special counsel investigation, you wrote a law review article, Washington University Law Review, that analyzed separation of powers issues. This was obviously before the Supreme Court's decision. You wrote that courts would most likely recognize immunity for a president's official conduct, but you acknowledged that the treatment of unofficial conduct was less predictable. Then on July 1st, 2024, the court ruled that presidents are immune from criminal prosecution for their official acts when those acts relate to their core powers under the Constitution, like the pardon power. The court also said that there was a presumption that presidents have immunity for their official acts more broadly. And Justice Roberts wrote that courts can't even consider the president's motives. So I'm curious your reaction to that. Did the court's decision align with what you predicted? Did it go farther than what you predicted? What are your thoughts?
I think it went a little bit further. And, it's funny, as I thought about it, many of the justices on the court today served in the executive branch.
Justice Roberts.
Yeah.
They
understand the importance of allowing the president to make tough decisions without fear of retribution, without consequences in the future, without being second guessed by future presidents, without being prosecuted by future presidents. And so in that sense, as I thought about it, I thought, I kind of, it felt like that's where I thought the court might go. Although going to the next step of not even questioning motive, to me, in the hands of someone with no integrity, leaves a big hole. And at a time when we have a Congress and a Senate, if not unwilling, unable to act, to investigate and to possibly remove a president who is acting outside of integrity, I think it leaves the United States in sort of a precarious position. I'm worried about it. Um, listen, President Bush appointed Chief Justice Roberts. I have the greatest respect for him. I really do. I admire him. I know he's how smart he is and how hard it is, particularly in these times, dealing with these branches of government um, in making decisions. But that decision has created opportunity for someone without integrity. And I'm not saying this president doesn't have integrity. What I'm saying is it appears that he's taking advantage of the opportunity to do things that he wants to do.
Justice Jackson, in her dissent, made a policy argument. She criticized the majority's ruling as altering the balance of power between the three branches of government. Her point was by weakening Congress's oversight power and granting excessive authority to the courts and to the executive branch, that this really, Justice Jackson's point was it actually undermines separation of powers by shifting excessive authority to the president and ironically to the courts. It's interesting. I'm curious what your take is on the point that she made about how the decision could alter the balance of power. Was she right? Was it something do we not know yet? Do we not have enough data points to really test her theory?
We don't have enough data points yet because I'd like to see a different Congress. Let's say, for the example, the Democrats take control of both the House and the Senate. I think then we'll have a better sense of how much this decision affected the balance of power in our system of government. So, today it appears that, oh my goodness, the president has all this unchecked power, but he's got a Congress that's controlled by Republicans, both houses. And so let's wait and see. I think it's too early to tell in response to your question.
You'd mentioned pardons, and you mentioned the January 6th pardons. I think it's undisputed the president's pardon power is a core executive function. It's enumerated in the Constitution. Supporters of the president did enter the Capitol. As of January 20th, 2025, 1,575 people have been charged in connection with the events on January 6th. And as he promised during the campaign, President Trump did pardon or commute the prison sentences of most of these people, including people that had been convicted of assault and the like. I just want to understand from your perspective how, since the president's power is what it is, I'm assuming that there is a pardon office and there was a process. And can you provide just a little insight into what the process was for considering a pardon during your tenure in the White House and the Attorney General's office?
During our tenure, during President Bush's term, and I suspect in terms before then, there is a pardon attorney's office at the Department of Justice, and that office receives requests for pardons. They do an investigation. They make a recommendation. That recommendation comes directly over to the White House Counsel, and so I would have conversations with that office directly. And my understanding is that is no longer the case. Now requests come straight directly into the White House or elsewhere, but not to the pardon attorney. Now, to be fair, it is true that at the very end of many administrations, even under the structure that I just described, there are what is called political pardons, where people come directly into the White House and make a request. And at that point, the president is less concerned about whether, if I grant a pardon in this particular case, how's it going to affect my reelection? Well, there may not be reelection concerns. There may be less concern about, well, how is it going to affect my legacy? And so I think there were political pardons. There were some that occurred at the end of the Bush administration when I was no longer in government, as I recall. But the usual way is the process. And the reason you do that is because you don't want it to appear that pardons are politicized. So you want that initial recommendation coming from a career individual at the Department of Justice, coming over to the White House, and then being presented to the White House Counsel, and then ultimately to the president, again, with the goal of reassuring the American public that the exercise of this constitutional power was going to be made consistent with certain principles and not because of political reasons.
Do you think pardoning the January 6th defendants was an appropriate exercise of the pardon power?
What do you mean by appropriate? How would you define appropriate? The president certainly had the authority to do it. Was it the right thing to do? From my perspective, and I'm not president, he can choose to do what he wants to do. From my perspective, it was a betrayal to the career prosecutors and investigators of the Department of Justice who did their job and did their job well. And so, was it appropriate? I think it was wrong. I'll just say it was. I would have recommended, if I were advising the president, Mr. President, do not do this. It will destroy the morale at the Department of Justice.
We've got a couple of questions in the Q&A, but I quickly want to pivot to a subject to just get your initial take on. President Trump has signed 210 executive orders so far this year. By way of comparison, Presidents Biden and Bush had only signed 77 and 54 executive orders, respectively, in their first years of office. So, consideration of executive orders, what was the process that White House Counsel and the Justice Department followed when you were serving in government?
It was an iterative process, and it would almost invariably begin at the White House. We would then communicate to the Department of Justice. They would then draft an executive order for us to consider, and it would then go back and forth. And at the end of the process, the Department of Justice would sign off as to the form and legality of that order. Did the president have the authority to issue this executive order? So that was a process we followed.
Now, supporters of the administration contend that executive actions are important to advance the president's agenda in face of entrenched opposition. Opponents of the administration contend the president's really pushing the outer limits of executive power through executive orders, including the firing of members of independent commissions and the like. How do you weigh the case on the advantages and disadvantages of sort of governing through executive order like this administration is doing?
Well, I mean, if you want to go fast, you use executive orders. But if you want to go far in really advancing your agenda, you do it through legislation. Why? Because the next president, first day, can wipe out all those executive orders. Or Congress can pass legislation that overrides those executive orders. And so I can understand the frustration. We were frustrated at times by Congress. And so being able to sign an executive order obviously is much easier and much faster, but it's not lasting. And so if you want, one key area would be like immigration. There are certain things you can do in immigration through executive order, but it's not lasting. The next administration, particularly one of a different party, could come in and undo all of that.
Well, the administration has skillfully utilized the so-called emergency docket of the Supreme Court to get matters quickly before the court, and the administration's been winning between, by my count, 83 to 93% of the time, at least as of last month. We've got a case being argued tomorrow on the president's tariff powers, being able to impose tariffs. How does the emergency docket differ from the process that you saw when people were challenging the Bush administration's policies? Because I'm sure there was litigation and there was, concerns and court cases, right?
Yes, there were court cases, some major court cases. In fact, I had to walk into the Oval Office 4 times and tell the President of the United States, Mr. President, the advice that your lawyers told you, saying you had the authority to do this or that. The Supreme Court has just said you don't have that authority. So that was a concern. The courts is being pushed to make a lot of decisions on a lot of legal issues. This administration has really pushed forward an agenda with legal implications, and it has really strained, I think, the work of the court. And the difference between the decisions on the emergency docket or cases on the emergency docket and the merits docket is that on the emergency docket, typically certain decisions are made without full briefing and without oral arguments oftentimes. Oftentimes those decisions are not signed. There have been some rare instances where they are signed, But that is the difference. And um, whether or not that process will continue remains to be seen. I, two of the members on the court worked for me, Brett Kavanaugh and Neil Gorsuch. Obviously, we put Sam Alito and John Roberts on the court. President Bush did, not me. And so I know certain members of the court very well, and I have confidence in them. And I at the end of the day, will I always agree with every decision? I didn't always agree with every decision President Bush made. But the only thing you can ask for is that people exercise their best judgment in making a decision. I'm hopeful that's what still occurs today.
So we're running very short on time. I wish we could spend time on the unitary executive theory, Humphrey's executor, and maybe you'll come back for a bonus round, perhaps early next year. We'd love to have you back. I'd like to close on an important topic, and that's the increase in political violence. I don't need to go through the laundry list of the recent attacks, assassinations, attempted assassinations. In our program materials, we have statistics on the rise of threats to bench officers. A recent NPR PBS News Marist poll found that nearly 1/3 of Americans, 30%, believe it may be necessary to resort to political violence to get the country back on track. Benjamin Franklin once famously was asked, what government have you formed? And he said, ma'am, a republic if you can keep it. So I'm wondering about your views, your reaction to political violence, and any concerns that you have around that, and what our institutions can do to address it.
Well, I mean, it's certainly true that there is no guarantee that there will always be a United States of America. And that's just a fact. And part of the beginning of the deterioration of the United States of America, one sign is increased political violence. I worry about it. I think most people, virtually everyone I know, responsible person that I know, is concerned about it, and we all condemn it. In terms of what we can do to address it, the rhetoric in our country today, in our politics today, has become so coarse and so divisive. Democrat, Republican, Democratic judge, Republican judge, us versus them, and it has to change, and it begins with our leadership. And the thing about it begins there, but does it really begin there? I sometimes ask myself, because we put these people in office. We voted for them. So maybe it's us. Maybe it begins with us. Maybe we should look inward in terms of how are we acting? How are we speaking? Why are we voting for people like we have in office today who have led us to this place?
I think Peggy Noonan recently wrote in the Wall Street Journal that we've become a nation of algorithms, and that's contributed, in her view, to political polarization.
Well, it's certainly true that we do appear polarized, and I think it's important that we understand that, this is a great experiment, this country of ours. We have people of different races, cultures, backgrounds, values, all trying to get together, all trying to get along and achieve a better life. And we need to be respectful of each other. And that really begins at home, no question about it. But it's vital that our leadership reflects those values. And I'm not just talking about in the White House. I'm just talking about throughout both federal and state government. We need to have leaders at the local level as well exercise those kinds of values of respect and civility and sacrifice. I think that's very important.
Well, thank you, Dean. Unfortunately, we are basically out of time. I will ask, and maybe perhaps in the first quarter of 2026, we could have you back to talk about what's happened since today, and also talk a little bit about your path to academia and what advice you would give to law students and lawyers today. But we're out of time. So thank you so much on behalf of the Beverly Hills Bar Association, the Beverly Hills Bar Foundation. We're grateful for your participation today. We thank you very much for coming in and for being with us today. And we wish you a fantastic day and a wonderful holiday season. And we'll talk to you next year, if not sooner.
Same to you, Fitz. Thank you.
All right. Thank you, Dean.